अब क्या करूं? नहीं, इस पर मैंने कर दिया भाई।
Hello everyone. Can you hear me? Hello. Hello. Hey everyone. Can you hear me? Great. We will be starting in a couple of minutes. Let's wait other to join and then we will start.
Hello everyone, welcome to Nyay Prayaas Foundation online session. I hope I am online. I am audible to all you. So guys, this is our first YouTube live. This is our first effort to start our online sessions, broadcasting our legal guidance sessions. So at present, we'll have you'll have option for messaging through live chat. You'll also have options of sending the live feeds as well. So right now we'll discuss about our today's topic. I have got the messages. Yes, audible. Great. So once again, welcome everyone to our first online YouTube. This NPF session is continued every Saturday previously through our online meetings, but today we have started this just an experiment. So how we can take it ahead. So आज का जो हमारा टॉपिक है, as you all must be aware of it. We have very few members today, so we'll just start with the discussion. How to prepare yourself for interim maintenance arguments, things to remember while addressing interim maintenance, and judgments to rely upon denying interim maintenance. So, as you all know, the entire matrimonial disputes, matrimonial litigations evolve around the maintenance and the monetary facts, monetary aspects only. The most common thing in matrimonial disputes is a criminal matter of 498A and other relevant sections. But apart from that, there is protection of women, from Domestic Violence Act. Other one is CRPC 125, which is now 144 of BNSS. Third is HMA 24, where maintenance pendant light is also given. Somewhere in GWA, Guardians and Wards Act, voluntary maintenance is allowed on the consent of both the parties. However, GWA cases do not have any specific maintenance aspect, but still we have seen many courts have, with the consent of both the parties, have allowed maintenance in GWA as well, for the interest of welfare of the child, for the best interest of both the father and the child, while they are granting interim maintenance, while they are granted visitation meetings in children room or somewhere else. So there are 4 5 aspects where a wife or a aggrieved lady can claim maintenance from the husband. Yes, we do not, please do not interrupt in between by posting your WhatsApp chats in our groups. Yes, there is no video right now. We are still, this is our first, so we'll try to go live with our live streaming as well as with our screen sharing options of various judgments. So wait for it. Do not post your, I request members who are posting in our groups, please do not interrupt in between. It actually interrupts and disrupts the flow. So as I was telling you, there are different aspects where maintenance can be claimed. And now after 2020, year 2020, after the guidelines laid down by Honorable Supreme Court of India in Rajneesh versus Neha judgment, both the parties have to give their assets, income and liabilities affidavit, which was at that time only few courts, few jurisdictions of Delhi and Punjab, Haryana were taking into account the Rajneesh versus Neha similar kind of judgment of Kusum Sharma and Mahinder Sharma. So now what happens is, across India, after this judgment, this income and asset affidavit goes mandatory. As per Rajneesh versus Neha judgment, it is mandatory to to file your income and asset liabilities affidavit along with your bank statements and your ITRs and your salary slip, if that is applicable, by the party who is claiming maintenance, and at the same time by the respondent husband also need to file his income and asset affidavit. So In NPF, we continued filing of affidavits on the very first stage itself, at the initial stage, along with your written statements, and that has helped many members. But we have also seen at the same time that majority of petitions claiming maintenance, whether it may be DV petition under section 23 to 2 of DV Act, or 125 maintenance, interim maintenance, or HMA 24, they were not supported by Rajneesh versus Neha affidavit, or they were not supported by complete bank statements, as well as ITRs, as well as statutory documents. So what we at NPF started to move an application uh, directing the petitioner to file 3 years bank statements and necessary documents along with the petition. And we, in our preliminary objections of our written statements only, mentioned this fact that since petitioner has failed to comply with Rajneesh versus Neha judgments, since the petitioner has failed to submit her income and asset affidavit either completely or without the statutory norms of bank statements, 3 years bank statements, or ITRs. So respondent crave leave to file a separate reply to the interim maintenance application as and when the petitioner is filing her income asset affidavit. So this also became a milestone, and NPF members during the litigation filed RTIs in multiple courts, district courts in Delhi, and at the end, many district courts filed made a circular. Registry department was ordered to not accept any maintenance petition without Rajneesh versus Neha affidavit. Then again, the similar matter came to Supreme Court, and Supreme Court once again directed all the high courts, Registrar General of all the high courts, to ensure compliance of Rajneesh versus Neha judgments along with the maintenance petitions. So now you all might be aware that sooner or later, either on the first day itself or on the second or third court hearings itself, petitioner is bound to provide her bank statements, ITRs, salary slips, if that is applicable. Otherwise, courts are asking for a written affidavit on behalf of the petitioner for not having a PAN card, for not having any bank accounts, for not having any salary slips, or not submission of income tax returns. So now what is happening? Our members as well as many others have approached the court, and courts are now taking into consideration before adjudication of interim maintenance application. Either both the parties have to file their bank statements, their requisite ITRs, or they have to file an affidavit duly deposing the fact that they do not have any PAN card, they do not file any ITRs for the subsequent periods, or they are not having a salary slip, or they are not having any bank accounts. So, what interesting part comes out from this? Earlier, when the petition was filed, courts were entertaining the plea that wife is a non-working, fully dependent on husband, but now a separate affidavit has to be taken into record before adjudication of the interim maintenance. So multiple cases, wives have deposed or have not pressed for their interim maintenance after the courts have directed them to file a affidavit of not having any income, or they are not having any bank accounts, or they are not having any ITRs. So it has been seen with due progress since 2021-22, when we started this idea of giving our affidavits on the very first court hearing itself along with the WS. Then we were able to, our members were able to go ahead and seek directions from the court to ensure that compliance of Rajneesh versus Neha affidavit is done by the petitioner who is claiming maintenance. And as a result of this, courts have taken into consideration that yes, petitioner is mandatorily have to file an affidavit whether she is having any bank accounts, or even in some cases it has been taken into consideration how many bank accounts were held, what are the bank accounts active. Even if the accounts are closed, their bank statements have to be brought on record before adjudication. So what matters is both the parties are constrained to go with their pleadings from their income affidavit only. Someone claiming 10 lakh rupees maintenance will not be able to argue anything when they have bank statements of the both parties, when they have salary slip or husband salary slip or ITRs. So courts have a greater aspect of adjudicating the interim maintenance against the affidavit filed by both the parties. Now, when you are both the parties have complied with the Rajneesh versus Neha guidelines, both the parties have completed their pleadings, written statement has been filed, replication has been filed or not, but both the parties have filed their income and asset affidavits, their bank statements are taken on record, or their separate affidavit is taken on record related to ITRs or PAN card or bank statements. Now, when you go for your interim maintenance arguments, there will be three aspects. Number one is one person who has admitted that she is working. Second person, second aspect will be second aspect will be she has claimed in the petition that she is not working, but now since there has been affidavit, she has came to the court assessing, yes, she is assessed to income tax and this is her bank statements. So now it is easy for you to argue that at the time of filing of the petition, petitioner has claimed that she is not working, whereas the documents brought on record now shows petitioner is working. In most of the cases where the child is not involved, the petitioner or the counsels keep on lingering this, or at the final stage when there is no more possibility to linger on the case, they themselves do not press for the interim maintenance. We have seen in many cases where the wife has filed affidavit with working as a government teacher or a government employee, but at the time of filing of the petition has mentioned that she has no source of income or she is living at the mercy of their parents. So at this time, they do not have any other choice either to delay or to not press for their interim maintenance. But when there is a third aspect toward the child, if there is a child out of the matrimonial bliss, out of the wedlock child is born, then they only press for the child. And courts in many of the judgments have taken into consideration that it is the duty of the father to take care of the expenses toward the child. and there have been exaggerated without any bills, without any documented evidences. Wife has filed claimed maintenance for the child to the tune of 50,000 or 1 lakh or 2 lakh, citing their school fees or their medical issues or towards their extra activities or tuitions or anything. So this is the third aspect where child is involved, and interim maintenance has to be argued. In the first two scenarios, there is no need for the courts to even go for the argument for interim maintenance, because in one condition she has admitted, on the other condition she has not pressed for her maintenance, because she has now shown her gainful employment. In the third aspect, when it comes to child, then the matter starts for the arguments. Now, when these arguments are going to be heard, the our today's topic discussion goes with this topic itself. What, how we have to address our arguments. That is the first and the foremost thing, where it has to be adjudicated and how it has to be adjudicated. In what lines your arguments should be. So we have only 25 thumbs up right now with 83 members. If you are able to hear me out, and if you think our conversation is good enough for your learning purpose, I should have more thumbs up, so that it will ensure that I am going on a right track, and our members, our participants are not bored, and we are addressing our session. Before this, keep on messaging side by side. That will also help to understand whether I am going on a right path or there is some other aspects as well. So that will include motivation to me. So in our previous sessions, we used to have interaction. It was a two-way communication, but today it is a one-way broadcasting itself. So we need members to ensure with their chats on, with their thumbs up and likes. That will ensure that we go in a proper phase. No need to message in the groups itself. It is there available on the YouTube itself. We have 92 members and 23 thumbs up have increased to 50. Thank you everyone. So we'll continue with our topic. Now, when you are going for arguments, both the parties have placed on record all the documents. Either you are doing in person. We have trained in Nyay Prayaas Foundation more than 100 members in NPF are contesting their cases in person. That is called PIP, and that is Nyay Prayaas Foundation's USP. So either you are contesting in person or you are helping your advocate to address the arguments. There has to be 2 points which has to be addressed on the very first go itself, that these are the discrepancies, these are the points court should ensure and take a adverse inference related to these 2 points. First, when she has in the petition said she is not working, and while submission of documents it has been assessed that she was working well at the time of filing of the maintenance petition itself. So now, this is the first and the foremost thing you should address, that these points of contentions must be taken into consideration, that at the filing of the case and till present she is continuously gainfully employed, whereas the said fact is not mentioned, even in the petition, even in the interim maintenance arguments. Now there may be an argument of a child, or there may be a argument of equal status. So once you are done with your first aspect of the points of contentions of wrong things or incorrect facts or misleading facts mentioned, then your point should go in two things. First, if your wife, I'll give you one example, very relevant one to most of the people. Since both the parties have filed their income affidavits and it's almost been 6 months to 12 months, now the matter has been put up for arguments. And if your wife, petitioner, who is claiming maintenance, is right there at the time of adjudication, and your documents, bank statements are almost 1 year or 6 months period, past period, then you should always mention that since the petitioner is here and court under rule 10 of CPC or under section 165 of Indian Evidence Act must record the statement of the petitioner, where she is working and employer name, and she has only these two mentioned accounts only, because at the time when the submissions were made, many of the parties, we have seen members, we have seen in many of the cases, wife have left the job and filed the affidavit, then she has again joined another organization, or she has switched one organization. In one of the case, wife was working as a assistant professor in one of the renowned college, but at the time of adjudication her employment has changed to a more distinguished university, and she was forced to record her statement under order 10 CPC on SA, that is Solomon information, that yes, she is now working in XYZ university and now her gross and net salary is 85,000, where she has claimed, submitted the documents of only 48,000 to 53,000. So that was the first aspect. You have almost won 50% of your battle, because your jackpot has hit. You were till present fighting with 48,000 to 53,000 maintenance, that she is only having 53,000 of per month gainful employment and having a child, and you are having much more, two-fold or four-fold, 4 times the salary. Now अचानक से जब ये नया फ्लैट सामने आ जाता है, जो आपका जैकपॉट हिट कर जाता है, क्या वो 90,000 कमाती है, और अभी तक तो आप प्रिपरेशन में आए थे 53 से डिफेंड करने के लिए, अब आपको पता लगता है कि 90 सैलरी डिक्लोज हो गई है, तो आप 50% अपना केस अपने कंट्रोल में ला चुके हो. So this is one more strategy that you should always say, that court may record order 10 CPC statement of the petitioner. There might be a chance both the parties are asked to give that statement in regard to their present bank accounts, or both the parties may be asked to record their statement under 165 Indian Evidence Act, and it is similar to 165 of Bharatiya Sakshi Adhiniyam, their net and gross salary. So it can be both ways, and there is no hard and fast rule that only petitioner has to do it. It can be done. It can be done for both the parties, or it can be done for only one party, that may be you also. So you have to be prepared And now once this statement has been recorded and your present salary, because once you have asked advanced your arguments on the very first go, that let the court first record her statement of her present employment and present salary, then the other party panics, and panics to this regard that he knows something about my present salary. That is why he is asking me to record the statement. So in that case, in that scenario, you have won half of the battle. Now, coming to the next point, when these statements by both the parties or either one of the parties have been recorded, many courts find it justified. It is the advocates or your person contesting their cases to ask the court to record their statement. Otherwise, courts are more than happy to record these statements just because it makes their reasoning towards grant of maintenance or denial of maintenance more easy, more convenient in a shortcut method. So they are more happy to get this statement recorded by either parties or both the parties. And no offense, you have nothing to hide. You have already shown your bank statements, you have already shown your income, assets, liabilities, affidavit, your ITR, your salary slip. So you don't have to worry. You will be able to record your statements. There may be some possibilities. Now your salary has been increased, but at the same time, your wife's salary has also been now placed on record. That is a once you are very sure that your wife is not working, she is not having any means, then there is no point of recording the statements. In one of the cases that becomes one of the major landmark cases of perjury, where court has taken the cognizance and issued show cause notice and initiated a state case against one of our members' wife who has concealed her bank statements. That is also on our website nyayprayas.org. We have masked the names of the parties. We have masked the concerned court details as well. And I have personally, as well as our members, have seen that judgment is being used by many other members or many other organizations or maybe by petitioners as well, where there is a concealment. So that is a very landmark judgment in itself. It's a 14-page judgment clearly showing what has been concealed by the wife and what respondent has pleaded and what documents have been placed on record. It also that judgment itself shows when you have to file perjury, you have to ensure yourself that you have got the sufficient material to be placed on record before initiating the perjury. That 14-page judgment is one of the very well written, reasoned order judgment by the learned trial court, one of the district courts of Delhi. तो आप लोगों को ये बात समझनी पड़ेगी कि जब आप इंटरिम मेंटेनेंस के आर्गुमेंट करने जा रहे हो तो उसमें 4 एस्पेक्ट होते हैं। पहला एस्पेक्ट है कि वाइफ ने झूठ बोला है और अब ऑन रिकॉर्ड आ गया है कि वो कमाती है। हो सकता है वो लिंगर ऑन करे, हो सकता है वो आर्गुमेंट ही ना करे और वो अपनी मेंटेनेंस की पिटीशन को ही नॉट प्रेस कर ले। जहाँ पर वाइफ को लगता है कि गैप बहुत है सैलरीज में, तो वहाँ पर दोनों पार्टीज की सैलरीज में बहुत ज़्यादा डिफरेंस है, तो वो लोग आई एम unable to control my लाफ्टर सबसे आगे लड़के कौन? एनपीएफ वाले, एनपीएफ वाले. आई डोंट नो हु हैज रिटन दिस, बट इट इज a very amusing. So I request, keep on making these comments so that it gives motivation. But still we'll continue with our topic. So आप लोगों को ये समझना है कि अगर आपकी वाइफ वर्किंग है और आपके केसेस में 6 महीने, 8 महीने, साल भर का, ऐसी बहुत सारी जगह पे पेटिशनर हो या रिस्पोंडेंट हो, चौड़े में अपना लिंक्डइन का प्रोफाइल अपडेट करते हैं या कहीं ना कहीं ऐसी जगह पे अपना प्रोफाइल एडमिट करते हैं कि नाउ दे आर स्टार्टेड वर्किंग इन Infosys or Google, or they have shifted their job from this company to this company. तो उस जगह पे आपको ऑर्डर 10 सीपीसी या 165 भारतीय साक्ष्य अधिनियम के अंडर में स्टेटमेंट रिकॉर्ड कराना है अबाउट लेटेस्ट एम्प्लॉयमेंट डिटेल्स, इन हैंड सैलरी, ग्रॉस सैलरी, नेट सैलरी एंड टोटल नंबर ऑफ बैंक अकाउंट्स. लेकिन ध्यान रखिए ये सब तभी कराना है जब पेटिशनर सामने कोर्ट में हो, नहीं तो आपका हथियार खाली चला जाएगा क्योंकि पेटिशनर है नहीं और आपको दूसरी पार्टी को प्रिपेयर करने का मौका मिल जाएगा. तो यू हैव टू एंश्योर दैट दूसरी पार्टी जिसका आप स्टेटमेंट रिकॉर्ड कराना चाहते हो वो कोर्ट में मौजूद हो. नेक्स्ट कमिंग, जब ये सारी चीज रिकॉर्ड हो जाए, जब ये सारी चीजें रिकॉर्ड हो जाए तो उसके बाद आपको उनके बैंक बैलेंस, जितनी भी बैंक स्टेटमेंट्स हैं, उनको अच्छे से एसेस करके अपनी पूरी तैयारी के साथ कोर्ट में जाना है व्हाइल एड्रेसिंग योर आर्गुमेंट्स. आई विल गिव यू वन एग्जांपल, एक छोटा सा उदाहरण. वो कहते हैं मेरे पास पैसे नहीं है, मैं अपने माँ बाप के ऊपर और भाई बहन पे, मर्सी पे जी रही हूँ. आई एम फेसिंग वैग्रेंसी एंड डेस्टिट्यूशन. जब आप उनकी एसआईपीस, जब आप उनकी फिक्स्ड डिपॉजिट, जब आप उनके गोल्ड बॉन्ड्स, जब आप उनकी इन्वेस्टमेंट्स के बारे में कोर्ट को अपने सेकंड आर्गुमेंट में लाएंगे कि कोर्ट में असेस दिस पेज वेयर शी इज मेकिंग 10,000, 15,000, 5,000, whatever is the amount towards monthly SIP mutual funds, or she is making yearly LIC investments, or the other party is going abroad, visiting abroad, enjoying a good social networking in Goa or Bangkok or New Zealand. So that can also be placed on record. जब आप लोग इस चीज को कोर्ट के सामने दर्शाने में कामयाब हो जाते हैं कि उसके पास सफिशिएंट पैसे हैं इन्वेस्टमेंट करने के लिए, घूमने के लिए, उनके पास अगर वो 5 लाख रुपए की आईटीआर भर रहे हैं, उसमें से 2 लाख रुपए साल का वो सालाना इन्वेस्टमेंट कर रहे हैं, तो देर इज नो पॉइंट ऑफ डेस्टिट्यूशन एंड वेग्रेंसी. अगर आपके पास बैंक स्टेटमेंट्स को आपने अच्छे से इवैल्यूएट किया है, क्योंकि अब मेजॉरिटी नंबर ऑफ पेमेंट्स जो हो रही हैं वो यूपीआई से इंटर बैंक ट्रांसफर्स होते हैं. अगर आप उन चीज़ों को ढंग से एसेस कर पाते हैं, अगर आप ये चीज़ एसेस कर पाते हैं कि उसकी सैलरी हर महीने 50,000 आती है और उसका बैंक बैलेंस जो है वो हर महीने 5,000, 10,000, 15,000 इंक्रीज हो रहा है, then this is also a point for denial of interim maintenance, that she is unable to spend her whatever salary she has admitted. Now, once you have assessed, because you are a respondent in majority of cases, you have to defend maintenance, even it is DV Act, even if it is a HMA 24 or a 125 petition. यू मस्ट एंश्योर दैट यू लुक इनटू द फैक्ट्स। आप लोगों को ध्यान रखना है, जो पहले वाली पार्टी ने आर्गुमेंट किया है, उन्होंने आपकी सैलरी बताई है, आपके एक्सपेंसेस बताए हैं, आप उन चीज़ों को उस टाइम पे रिपीट ना करके आप अपने पे फोकस्ड रहें कि देखिए जी 2 लाख रुपए माँ को दे रहे हैं, देखिए जी 2 लाख रुपए भाई को ट्रांसफर हो रहा है, और ये अनआइडेंटिफाइड बहुत सारे क्रेडिट एंट्रीज आ रही हैं। सो नाउ वी हैव टू असेस judgments in our favor. It is not the fact that law is always against you. There are multiple judgments where law is also in favor of denying maintenance to working wives, well capable, earning wives. There are judgments to the tune that both the parties are equally qualified, both the parties are gainfully employed, they must share equal expenses towards the child. So there are judgments. It is not that husband is always penalized. In majority of cases, yes, it is. But we have seen in many of the cases for our members where we have guided members, they have contested with the implementation of our strategies. इतना पक्का है कि आपको एग्जॉर्बिटेंटली हाई मेंटेनेंस नहीं लगेगी अगर आप ये सारी चीजें कोर्ट में एनालाइज करके मेहनत करके कोर्ट में सामने रखोगे। 4-5 जजमेंट्स हैं बहुत फेमस। उन जजमेंट्स को अगर आप ध्यान में रखेंगे, दैट विल गिव यू एन एज। वन जजमेंट, अंजू वर्सेस रिंकू दहिया, दिल्ली हाई कोर्ट जजमेंट इज देयर, जहां पर कोर्ट ने बोला है कि दोनों पार्टीज इक्वली क्वालिफाइड हैं, वेल वर्किंग हैं, दे बोथ शुड go ahead with sharing of the expenses. It is also mentioned in Rajneesh versus Neha judgment. There is also one more judgment, Padmaji versus State, where the it has categorically mentioned that the expenses towards the children or the child shall be borne by both the parties who are working. There is one more judgment, मेजॉरिटी ऑफ केसेस में जब मेंटेनेंस क्लेम करने की बारी आती है, अगर उसने अपने आप को अनएम्प्लॉयड दिखा दिया है, तो एक जजमेंट है जिस पे आपको रिलाई करना चाहिए। इट इज ऑल्सो अ दिल्ली हाई कोर्ट जजमेंट, दमनप्रीत वर्सेस इंदरमीत। दमनप्रीत वाली जजमेंट में वाइफ ने अपनी नौकरी छोड़ दी थी ये कहते हुए कि मेरे पास तो स्ट्रेस हो रहा है केसेस का, मैं बच्चे को टेक केयर करने के लिए नौकरी छोड़ दी है, या मेरे को उस जगह से दूसरी जगह शिफ्ट होना पड़ा, बीइंग एग्रीव्ड। तो आपको, इट इज दमनप्रीत वर्सेस इंदरमीत, नॉट इंदरप्रीत। सो you should analyze these kind of judgments. There are multiple more judgments, Sunita Kachwa versus Anil Kachwa, where Supreme Court has mentioned that inability to maintain herself is a precondition for grant of interim maintenance. अगर आपके पास ऐसा कोई भी साक्ष्य नहीं है कि आप अपनी मजबूरी में जी रही हो, भुखमरी में जी रही हो, तो उसके अगर आप ये नहीं दिखा पाती है तो आपको मेंटेनेंस नहीं मिलनी चाहिए। Inability to bear your expenses is a precondition to for grant of maintenance. So this is in Sunita Kachwa versus Anil Kachwa. There are multiple more judgments जहां पर मैटर्स लोअर कोर्ट से हाई कोर्ट में गए हैं, हाई कोर्ट से सुप्रीम कोर्ट में गए हैं, और वहां पर मैटर्स 142 में सेटल हुए, आर्टिकल 142 ऑफ कॉन्स्टिट्यूशन ऑफ इंडिया which empowers Honorable Supreme Court of India where it has the sole power related to IRBM, irrevocable breakdown of marriage, and give divorce to both the parties and decide whatever terms of alimony or maintenance has to be provided. So there are multiple judgments. अगर आप लोग सुप्रीम कोर्ट की जजमेंट्स पढ़ते हैं तो आपको समझ आएगा कि सुप्रीम कोर्ट में मल्टीपल जजमेंट्स में पहले की उनकी पास्ट जजमेंट्स के बारे में बताया जाता है। उनके पहले की जजमेंट्स को बता के ही आगे का क्वांटम या नया केस में डिसीजन दिया जाता है। तो ऐसे ही जजमेंट्स हैं जहां पर स्टेटस ऑफ द पार्टीज, भारत हेगड़े जजमेंट इज देयर. There is one more judgment where Supreme Court has said that Rajneesh versus Neha in itself is a complete code while deciding maintenance cases. It has everything. आप में से जितने भी लोग रजनीश वर्सेस नेहा जजमेंट पढ़ते हैं या आपने अगर एक बार पढ़ी है या दो बार पढ़ी है तो आप उसे फिर से पढ़िए। आप जितनी बार पढ़ेंगे आपको उतनी बार नई चीजें देखने को मिलेगी। उसके अलावा बहुत सारी जजमेंट्स हैं जहां पर कोर्ट ने ये डिसाइड किया है कि मेंटेनेंस और एलुमनी कैसे डिसाइड हो। अगर आप उन चीजों को पढ़ेंगे तो आपको एक जजमेंट मिलेगी, किरण ज्योति मैनी वर्सेस अनीश प्रमोद पटेल। ये जजमेंट बहुत कुछ आपको बताती है। सिमिलर जजमेंट, I think we have 97 members. It has dropped down to 97 from 104. So I think judgments या तो आपको पसंद नहीं आ रही या आपको कन्वर्सेशन जो है समझ नहीं आ रही। So I'll try to explain both in English and Hindi. कुछ जजमेंट्स ऐसी होती है जो जरूरी नहीं है आपके केस से रिलेट करे, लेकिन ऐसी बहुत सारी चीजें हैं जहां पर अगर आप पढ़ेंगे तो कुछ ना कुछ आपके बारे में बताया जाएगा, आपके केस से रिलेटेड होगा। वन जजमेंट ऑफ दिस रिलेटेड टू मेंटेनेंस एंड डिसाइडिंग द क्वांटम ऑफ मेंटेनेंस में यू कैन नोट डाउन। वन इज किरण ज्योति मैनी वर्सेस अनीश प्रमोद पटेल. This is very important judgment which gives you the clear background how quantum of maintenance and how alimony has to be decided. Similarly, Ashok Hura versus Rupa Bipin Zaveri judgment is there. It is also a very good judgment. Hitesh Bhatnagar versus Deepa Bhatnagar, it is very good judgment. Praveen Kumar Jain versus Anju Jain, Honorable Supreme Court of India decided the quantum of maintenance 5 करोड़ रुपए। एक कपल को 20 साल से केस लड़ते हुए 5 करोड़ रुपए फुल टाइम सेटलमेंट फॉर दी वाइफ एंड 1 करोड़ फॉर दी चाइल्ड ग्रांट किया था। प्रवीण कुमार जैन वर्सेस अंजू जैन। सो देयर मे बी सम एस्पेक्ट आपको लगे कि 5 करोड़ रुपए दिया है, लेकिन आप सोचिए उस केस को जब आप पढ़ेंगे, जब आप उसको एनालाइज करेंगे कि दैट पर्सन हैज पेड 92 लाख रुपीस एज मेंटेनेंस। he was forced to withdraw his case due to maintenance, जो 15,000 से स्टार्ट होके 65,000 हुई, 65,000 से स्टार्ट होके 1,45,000 हुई, और फाइनली सुप्रीम कोर्ट ने देखा कि इसका कोई एंड नहीं है, चेंज ऑफ सर्कमस्टांसेस लगते हैं और चेंज ऑफ सर्कमस्टांसेस में नए फैक्ट सामने आते हैं और मेंटेनेंस 3 साल, 5 साल, 8 साल, 10 साल, फिर 15 साल के बाद बढ़ती रहती है हस्बैंड की सैलरी बढ़ रही है, उसके बाद वाइफ मेंटेनेंस के लिए, एनहांसमेंट के लिए चेंज ऑफ सर्कमस्टांसेस की एप्लीकेशन लगाती हैं और फाइनली कोर्ट ने बताया कि आपने 92 लाख रुपए तो दे दिए हैं, लेकिन अब आपको कुछ ऐसा पैसा भी देना पड़ेगा फॉर वन टाइम सेटलमेंट, जिसमें बेटा 28 साल का था, बीटेक, और वाइफ 20 साल से अलग रह रही थी, 4 साल की शादी और 22 साल का सेपरेशन एंड मैट्रिमोनियल डिस्प्यूट. Finally, court ordered 5 crore rupees alimony towards the wife and 1 crore rupees a child having BTech degree and at the age of 28. So there may be some judgments where you see exorbitantly high price have been paid by the husband or by the father, but court have given final divorce using the inherent power of Supreme Court of India under Article 142. क्योंकि अभी हमने बहुत सारे लोगों को केसेस में देखा है, चेंज ऑफ सर्कमस्टांसेस की एप्लीकेशंस लगती हैं और उसके बाद उसमें नया असेसमेंट होता है, नया असेसमेंट होने के बाद सैलरी बढ़ जाती है, तो 20%, 30%, 40% का इंक्रीज हो जाता है. बच्चे के नीड्स बदलते हैं, पहले वो 5वीं क्लास में पढ़ता था, आज वो 12th क्लास में पढ़ता है, उसके बाद बच्चे को अब हायर स्टडीज के लिए जाना है. तो आपको ये समझना पड़ेगा कि अगर आप केसेस को डिले करेंगे, अगर आप केसेस को स्ट्रांगली कंटेस्ट नहीं करेंगे, तो ये चेंज ऑफ सर्कमस्टांसेस लगते रहेंगे एंड देयर इज नो एंड ऑफ दिस एनहांसमेंट्स. एनहांसमेंट को लेकर एक बहुत इंपॉर्टेंट जजमेंट है, जहां जहां लोगों का मेंटेनेंस एक बार लग चुका है और उसके बाद वाइफ या पेटिशनर केस को कंक्लूड नहीं कर रही है, आप क्रॉस एग्जामिनेशन सही से नहीं कर पाए, आप क्रॉस एग्जामिनेशन में बहुत सारी चीजें फैक्टर इन नहीं कर पाए जो एलिगेशंस थे, तो एक जजमेंट आती है एस विजय कुमारी वर्सेस मोवेनेश्वर चारी. I'll spell it out, somebody can write it down in the chat box. S Vijay Kumari, VIGIKUMARI versus MOWNESHWARANCHARI, मोवेनेश्वरी चारी. दिस इज अ जजमेंट, वेरी इंपॉर्टेंट जजमेंट, बहुत छोटे से एस्पेक्ट से स्टार्ट होती है और पूरे डीवी एक्ट में कॉन्सेप्ट ऑफ चेंज ऑफ सर्कमस्टांसेस सेक्शन 25 ऑफ डीवी एक्ट को बहुत अच्छे से डिस्क्राइब करती है. सो ऐसा नहीं है कि आपने एक बार इंटरिम मेंटेनेंस आर्गुमेंट्स कर लिए, आपका इंटरिम मेंटेनेंस सेटल हो गया, उसके बाद आपकी सैलरी बढ़ गई, आप अगर ढंग से क्रॉस एग्जामिनेशन नहीं कर पाए, आप, क्योंकि 90% केसेस में इंटरिम मेंटेनेंस ग्रांट होने के बाद एग्जीक्यूशंस लगती हैं और जब तक पेमेंट्स क्लियर नहीं होती हैं तब तक हमारे पास क्रॉस एग्जामिनेशन नहीं होता है. तो इसलिए आपको ये इंश्योर करना है कि वंस यू आर ओवर विद योर इंटरिम मेंटेनेंस, इसीलिए हमने बोला है अगर बच्चा है आपके पास तो आपको पहले से ही वॉलंटरी मेंटेनेंस देना शुरू करना चाहिए, क्योंकि आपका मेंटेनेंस कुछ ना कुछ तो लगेगा ही. Somebody is writing these judgments are applied on second marriage also. Yes, there is no bar, there is no judgment which says that it is applied for only a specific first marriage, second marriage or third marriage. There is no possibility that there can be a discrimination. कोर्ट इस बात पर डिसाइड नहीं करता कि आपकी पहली मैरिज है, दूसरी मैरिज है, तीसरी मैरिज है, तो आपको ये सारी चीजें एप्लीकेबल होती हैं फर्स्ट मैरिज, सेकंड मैरिज, सब में. आपको अगर समझना पड़ेगा कि अगर आपके पास क्रॉस एग्जामिनेशन विल नॉट टेक एनी क्रॉस एग्जामिनेशन रिलेटेड टॉपिक्स इन दिस यूट्यूब लाइव, we'll be posting special courses for our NPF verified members related to PIP trainings and art of cross examination. We'll not talk about anything related to cross examination, how to do the cross examination on this YouTube live. This will be done within the closed group. It cannot be discussed in the ऑनलाइन प्लेटफॉर्म्स. देयर आर टिप्स एंड स्ट्रैटेजीज जो अभी हमने कुछ डिस्कस करी, ये दैट आर वेरी मच कॉमन. बट कुछ ऐसी स्ट्रैटेजीज होती हैं, बट ऐसे ऐसे पॉइंटर्स होते हैं जो आपको समझने पड़ते हैं, और वो सारी चीज़ें आपको यूट्यूब लाइव चैनल्स पे नहीं बता सकते. सो फॉर दैट विल पोस्ट इन आवर ग्रुप्स, न्याय प्रयास फाउंडेशन ग्रुप्स. इफ यू वांट टू गो ahead with multiple more judgments, then बहुत सारे कोर्ट्स में एक सबसे स्टेट पैटर्न है जो बोलते हैं कि देयर हैज टू बी अ एस्टैब्लिश्ड डोमेस्टिक वायलेंस प्राइमा फेसाई, देन ओनली मेंटेनेंस कैन बी गिवन. तो आप ये हमेशा मान के चलिए कि जब इंटरिम मेंटेनेंस का ऑर्डर होगा तो आपकी वाइफ ने जो एलिगेशंस लगाए हैं, उसके बाद आपने जो काउंटर एलिगेशंस या उसमें अपने रिप्लाई में लिखा है, वो सबसे पहले ऊपर मेंशन किया जाता है, और लास्ट में बोला जाता है कि सिंस मैरिज इज नॉट disputed, both the parties are living separately, is not disputed, prima facie there is a reason of staying separately due to violence as alleged, तो इसलिए इंटरिम मेंटेनेंस बनता है. तो ये स्टैंडर्ड लाइंस हैं, कोर्ट्स लिखते हैं, उसके बाद मेंटेनेंस ग्रांट करते हैं. बट यू शुड एंश्योर such facts, such incidents of concealment. There is one judgment of perjury, there is one judgment of coming to the court with unclean hands, that is Dalip Kumar versus State of UP. There is one more judgment of Sita Bain versus State of Gujarat. There is one more judgment of Messrs M/S Messrs Lilliput, where court have denied maintenance. We have members in a group जिनकी मेंटेनेंस इन जजमेंट्स के ब्याह पे, कंसीलमेंट ऑफ फैक्ट्स पे डिनाई की गई है. दैट द वाइफ, दैट द पेटिशनर हैज अप्रोच्ड द कोर्ट विद अनक्लीन हैंड्स, एंड यू शुड mention these judgments while addressing your arguments. When you are able to ensure that there are sufficient funds with the wife, when you are able to address the arguments on no destitution or vagrancy, when you are able to address the court with concealment of facts, then you should also mention these judgments. You should carry along with you copy of judgments, highlighting the aspects, relevant portions, flagging the relevant portions. बहुत सारे हमारे मेंबर्स, बहुत सारे हमारे ग्रुप के लोगों की जजमेंट्स में जो हम जजमेंट रिटर्न आर्गुमेंट्स में देते हैं फॉर डिनायल ऑफ मेंटेनेंस, जस्ट होल्ड ऑन गाइस. वो कोर्ट अपने ऑर्डर में भी लिखता है और जस्टिफाई करता है, रीजन ऑर्डर देता है. तो आपको हमेशा प्रिपेयर्ड रहना चाहिए, जजमेंट्स आपके पास हैंडी होनी चाहिए. ऐसा नहीं है कि कोई जजमेंट जो है, हमारे बहुत सारे मेंबर्स को हमने जजमेंट दिया है शिव कोटेक्स, that is not related to matrimonial dispute, but it has helped many members getting the rights closed for taking more than 2 adjournments. Those who are saying that strategy should not be open here on YouTube must ensure that what we are saying is already in public, it is already on the multiple platforms. We are not discussing any case specific guidance, we are not discussing any strategies. which are not in public. We are not talking about any illegal acts. So, those who think must do activism, those who think that we should not discuss on our YouTube channel or on YouTube live, they have to understand these things are readily available in books. These strategies are available by multiple platforms. We are here to tell you what is required. If you are not ready to understand that these are some aspects which are mentioned in multiple books, multiple legal seminars or conclaves, then आपको हमारे सिर्फ कोर्सेज ज्वाइन करने चाहिए. You may or you may not like it. Many of the members may not like that these strategies are being discussed. Yes, I can understand, but these something needs more members to be aware of. There, it is not that only Nyay Prayaas Foundation members who have to be benefited. We need members to be benefited who are not part of Nyay Prayas, who are not part of any other organization, and who are suffering from matrimonial disorders. So you have to understand, you have to make your comments, you have to under this point that we had 104 members. Then also we had only 73 thumbs up. We have very less comments, and it's already 1 hour and 1 minute of this session. I hope you have enjoyed this session. I hope you have addressed, I have been able to address your queries. We'll take it for next 2 to 5 minutes. If you have any questions, you can post in the chat box. I will try to explain and give my views. If you have any comments, if you have any point of discussion which I have left, otherwise we'll close this call. We have only 97 members. We have only 75 thumbs up. That means still people are not liking this session. People are not very much familiar with the new NPF YouTube. They are only liking two-way communication in our personalized verified calls. Yes, it is very correct. But due to poor activism, we are not taking question answers. There has to be multiple strategies related to mediation. Yes, there has to be multiple strategies. You should never open your cards on the first day. You should not open your final figure. Your first figure should not come the first, it should be the other party. Last judgment I mentioned was related to change of circumstances, that is already in the chat box mentioned. People who are thinking that giving a private member bill related to men's commission is going to help is a myth. A non ruling party member of parliament, we thank the member of parliament Sri Mittalji for what he has done is absolutely commendable. Similar task was done by ex deputy CM of Uttar Pradesh last year. Then also nothing happened, even though he was the ruling party in the central government in Union of India. And this time it is done from the Aam Aadmi Party MP. And people are hoping that we are going to get a men's commission. What will happen if we get a men's commission and we will have the chairman as so called Smriti Irani or somebody prominent to be very much inclined towards gender biasness. So the only way to contest your cases, only way to bring a change in the society is reforms which can be achieved legally, not by going with men's commission. What will happen if our MP, who has said filthy words about men, becomes the chairperson of men's commission, if at all it is made? First of all, Union of India will never going to accept, and bills will not be able to be passed which are a private member bill without having the majority from the government who is a ruling party. So stop dreaming about men's commission, stop thinking about doing activism. People people have come on roads thanking and making a voice, that is very correct, but the ultimate legal reform is only through legal remedies, and that is why Nyay Prayaas Foundation was made. And I think we are done. We are still not able to reach 90 96 thumbs up, so it's okay. We close this call. We had more than 100 members in the first call. We had more than 80 thumbs up, multiple chats, people asking their questions. So it was an interactive session. We'll go ahead with same kind of streaming with subscriber only calls without going for the open media. We'll share the link individually with our members who have subscribed. Ask members, ask your family members to subscribe. Like, we have, within a very short span, we have achieved 500 subscribers, but it is still low as per our group numbers and volumes. Okay, thank you guys. It's 1 hour 7 minutes, so I think we are done. Thank you for joining our first live streaming. We'll come along with new topics, and till the time we get good number of activism from our members, we'll not take two-way communication. We'll have physical meetings tomorrow at a designated place itself. Those who are thinking Parliament will scrap 498A, please look at the condition of our country. लाडली बहना योजना, 10,000 रुपये महिला योजना, and अलग अलग scooty योजना. So stop dreaming about 498A being scrapped. It is only and only legal aspect which can change this demography by virtue of landmark judgments, by virtue of the way we have contested perjury proceedings, interim maintenance, and other aspects. This is the only way to go ahead, contest strongly, and keep winning, keep motivating, keep doing activism. Thank you, everyone. We'll close this. अच्छा, एक मिनट